A warm and sincere welcome to each and every one of you to this, our second session in our Family Life Series 2024. So glad you could join us for this session. The Church of God at Gardens in St. James, Mile and a Quarter in St. Peter, and Silver Sands in Christchurch are partnering this year to bring you Family Life Series 2024. It is indeed our great privilege and pleasure. Family Life Series 2024 has as its theme, Healthy Families Matter. As a result, the focus throughout will be on family matters. Last Wednesday evening, we started with quite a riveting and informative session led by Dr. Renée Boyce, a member of the Church of God at Jackson, the focus of which was menopause and andropause. I'm sure that you would agree with me that that presentation was truly informative. We again say thanks to Dr. Boyce for a job very well done. And so oftentimes as individuals, and Christians are not excluded because Christians are people too, we accumulate wealth, and when we die, we leave no directive as to how that wealth is to be disposed. So very oftentimes, the ugliness of family members emerges as every family member fights to lay hold of his or her assumptive share. This evening, our focus will be on wealth and the disposal of wealth or the distribution of wealth, and will predominantly focus on wills. Mrs. Renée Simpson, a young attorney at law, is our presenter for this evening's session. As was the case last week, Renée will make her presentation, and we will then have the opportunity to pose to Renée any questions which we might have by placing them in the YouTube chat. I do encourage you to place your questions in the chat as we go along and not wait until the end of the session to do so. Please, ladies and gentlemen, allow me to share a bit of Renée's journey with you. Chartered insurance professional and attorney at law, Renée Simpson received her law degree from the University of the West Indies, Hayfield campus in 2017. She later obtained her legal education certificate from the U Wooden Law School located in Trinidad and was called to the bar in Barbados in the year 2022. Prior to this, Renée worked in the insurance industry for over 20 years and obtained her Chartered Insurance designation from the Canadian Insurance Institute in the year 2009. Renée presently works as legal officer with Trident Insurance. Renée is a dual citizen of Barbados and Guyana. She has held the position of Vice President of the Guyanese Association of Barbados, Inc. for the last 2 years. Renée is also an active member of the Barbados Bar Association and has engaged in limited private practice in non-contentious legal matters. Renée is married and has 1 son and 3 daughters. I am delighted this evening to present to you our facilitator for this evening's presentation. Help me to welcome Mrs. Renée Simpson.
Thank you, Minister Bellamy. Are you hearing me? Are you able to hear me?
Yes, we can.
Thank you very much. Thank you for your welcome. And also, I would like to say thank you for all the listeners and those who joining us today. It will be an interesting discussion, as alluded to by Minister Bellamy. And we will, I know this time it could be a touching time for some persons because of the nature of the discussion. And so I pause at this time to say if you're experiencing any loss within your family or friends, I am very sorry to hear and wish you God strength in getting through. Because I know sometimes, often we don't think about these issues until we experience some loss. So without further ado, I would proceed to the presentation. So I will get some help in sharing the slides. So often as the Bellamy would have said, we are, just a moment. Yeah, so often we would think about, or we may not think about what wealth we have, or when we die, what will happen to it. And this is to bring some level of understanding as to what we can do with the wealth that we accumulate during our lifetime. Now, this presentation would go into giving a brief introduction of what are wills. We would go through some definitions. We would also, that will be on the next slide, look at the validity of wills and their effectiveness. We would also look at some aspects of drafting a will and payments of debts and liabilities on the other slide. We will also talk about various activities, including failure to benefit under the will. We would also look at the application for a grant of probate and a little roadmap before we conclude. So there's a lot of exciting areas to cover, and we welcome your interactions, your questions, your comments. We will definitely facilitate responses. So bear in mind that our presentation will be governed by few various legislation. So we would have the Succession Act, Cap 249. We would also have the non-contentious probate rules, which we refer to from time to time. And we also refer to the non-contentious probate rules 1954 from England, because these all form the body of laws that govern how we deal with wills. So what is a will, one might ask? And the short answer is, if you look at the textbook definition, is that a will is a revocable declaration in a prescribed form made in contemplation of death, expressing the intent of the person making it regarding the matters which he intends to take effect after his death. So when we look at our Succession Act here in Barbados, it simply says a person may by his will dispose of all the property which he is beneficially entitled to at the time of his death, and which on his death devolves on his personal representatives. So we will move now to a few definitions just to make that a little clearer. And that will be, so definition of a standard will, again, it would be a revocable declaration in a prescribed form made in contemplation of death, expressing the intent of the person making it regarding the matters which he intends to take effect after his death. Now, there's also something referred to in our acts called the holograph wills. And a holograph will is simply a will which is written throughout in the proper handwriting of the testator. And it need not be signed nor witnessed according to our laws. So that means that you out there, anyone could write a will. But we will go into the particulars as to how to make that will valid and what would be required to make it effective and how we would use our drafting skills to give the intent of the testator or you yourselves. So we can move on to another slide. So when we talk about the testator is the person who has written and executed the last will and testament that is in effect at the time of their death. Now, sometimes you say the last will and testament, but some persons are in the habit of making more than one will. And so we can see that that can cause a little bit of confusion as we go along. So the testator is the person who is actually writing, making his last will and testament. We could go on to the other definitions that may be of use. So when we look at the beneficiary is a person who is designated to receive from the will. And some examples could include a spouse. We could look at children, we could look at charities, friends, and families. All these people, all these persons can inherit from a will. So we can move on to another definition, which would be the executor. And the executor is a very important person in respect of wills. That person is your personal representative or administrator. So that when we pass on, the executor would be the one that represents us and our interests as we would have expressed within the will. And they would administer the estate, so to speak. Can move to the next slide. And we have something called undue influence. Now, undue influence in the simplest terms would be a situation where someone exerts pressure on someone else to hand over personal wealth or property, as the case may be. And they might even influence that person to draft a will or to have a will put in place by withholding certain benefits the person might have. And it could come in the form of you caring for an elderly aunt or your mother or your father. And you say, well, if you don't do such and such, or give me the house or give me the land or whatnot, I will not, give you your meals every day. I will put you in a home. Whatever it is a pressure that should not be placed on someone to give you any gift. So we can move on again now to the next slide. So another definition we will look at is in respect of a grant of probate or letters testamentary. And this is basically an official document issued by the Supreme Court, which signifies that the court has confirmed under the named executor or legal authority, enabling him or them, because it could be more than one, to administer the deceased estate. This is the grant that we would hope that our executor, once we have drafted a valid will, will be able to get and obtain from the court. So we can move on to the next slide. So when we go to what makes a will valid, and the validity of the will is governed by our rules and our legislation. And it says in the Succession Act that a will is only valid if it is made by a person who has attained the age of 18 years or has been married and who is of sound mind. A will shall not be valid unless it is made in writing, signed at the foot or end thereof by the testator or by some person in the presence and by his direction. So we have a few things coming out. And for instance, the will should be in writing. And when we say in writing, it could be handwritten, it could be typewritten, it could be printed, or a combination of these methods. The case law that we would have referred to sometimes shows that there's no special form of words that would be required when writing a will. And also, what is also very important is that the signatures that are assigned to the will are valid and are presented. And what we mean by this is that the rules would tell us areas such as we can't have a signature when the will on a separate page and nothing about the will is above it. That wouldn't be valid. The persons who are witnessing the will, they would have to sign in the presence of each other and in the presence of the testator. Another reason that a will could be invalid as well is if you have someone signing the will that is also going to benefit from the will. So there are quite a few things to bear in mind, and I believe that's why most persons would tend to have an attorney at law draft a will for them and follow through with the formalities, because they would be best persons to know how to go about drafting the will. Notwithstanding, you can still have a will written by an individual that could stand the test of time. And sometimes it just has to be a few words. And in one case, the person said, all for mother. And it was discovered that he meant his wife because he referred to his wife as mother throughout his time. So, and the court was able to give effect to that will and give over his personal property to his wife. So, another area we would look at is the mental capacity to make a will. Now, when you have mental or animus testandi, this is the mental capacity that would allow a person to make a will. So very often we have persons in our community that may be suffering from dementia, or they may have some mental challenge, or they may have lucid moments or intervals. They would be deemed as not having the mental capacity to make a will. So what is important for us to do is to ensure that when we're drafting a will, that the person, the testator, has a medical certificate alluding to the fact that they are capable and have the mental capacity to make a will. Equally, when attorneys at law would be dealing with their clients, they would be able to ascertain a certain degree whether the person, is mentally capable of making the will, whether they have the knowledge and approval and they understand that they're disposing of their property in the manner that they are disposing of the property. So that's why it's important, even when we're thinking about a will, we should think about it when we're much younger. It has its challenges, yes, but you don't want to wait until you're older and you can no longer appreciate certain things in life, or you have some level of undue influence for someone to come and take you up and say, oh, let's go make this will, or you feel pressured to go into a situation like that. You can make a will prior to that, when you're young and able and you're not really quite contemplating that. So another area I would look at, if we go back to the other side as well, is to talk about the when the animus testandi or the mental capacity should be in effect. And that would be at the time the person is giving the attorney their instructions as to what they're going to give, and also at the time when they finally execute those instructions, because sometimes it could be a mixed bag, right? And the court will look to see what the intent of the testator is at the end of the day. So you don't want, when they give you the instructions, they were lucid, but then somewhere along the line something happened, and then someone rushed and drafted a will quickly, and thereafter executed the will, but the person was not in their sound and disposing mind. Equally, when someone is troubled, say with sight, they're blind, and they want to do a will, the attestation clause or the signatures that attend to that will must be signed in a particular way, whereby the attorney at law will provide some note that they would have read over to the testator and had the approval of this testator before they signed off on the will. So that is very important, or there could be challenges. So now that we have spoken about most of the items on that slide, we can talk about the fact of the validity of the will. So we know that we must have the will in writing. There must be a signature of the testator at the end of the will. And we also know that you should have two witnesses and they should sign in the presence of each other. Now, to have the effectiveness of a will, the effectiveness of a will is governed mainly by proper instructions. So when your attorney is having conversations with you concerning your will, you must give all the information that is relevant. So there must be proper planning and advice and proper drafting. And by that, you will understand as we go along. In effect, you don't want the will to be contested or have any flaw in it so that your wishes wouldn't be carried out. So it's important that you give all the information to your attorney, or that you contemplate all these aspects if you're going to draft the will yourself. So we can go to the next slide. So what you want to have happen is to have clear instructions. You have to know who is the testator. You have to give full description. Sometimes in the Caribbean, we tend to have lots of aliases, and we have, our home name, the name we were given at birth. You may have the name we know not at work, and so on and so forth. But all those names will become relevant if you're going to have a will. So it's important to take cognizance of all the names that you hear people calling you, so that you can have the right drafting in the will and it wouldn't be shot down, so to speak, or fail based on the fact of not having the correct name. So who will be your executor? That is a very important question, because that person is in a fiduciary duty, and that person should have your trust and your confidence so that you are sure that they're going to carry out your wishes. So the executor, you would also want, or you would hope that the person would outlive you and that they would be able to do as you would have asked. But as you will see, there are many things that can happen that would cause sometimes the executor may die before you, or the executor might renounce his role. But that wouldn't, altogether void the gifts that you're given. There are just other ways that the court would look and assess your will based on all the evidence. You also have to think about things such as, who will you appoint in your will to be guardian over your minor children? Oftentimes we may not even think about that, because you might think, okay, we will be around for a long time. We will have this long life and our children will grow up and we will hopefully pass before them. Yes, but then they will be grown. But we may not think that maybe if we pass away tomorrow, our young children may not have anybody to take care of them. So it's very important for us to appoint a suitable guardian over minor children. And obviously, if they grow up and the will isn't probated until they're adults, that's fine. But it's always safe when you draft in a will to think about the consequences to minor children. In addition, you will have to also bear in mind, what do you actually have to give? Some people think they don't have anything, Oh, I don't have anything, I don't think. But then you might have an art collection. You may have your clothing. You may have your jewelry. You may have your car. There might be a lot of things that you thought you didn't have to give that you would have, but then you would want it to go to a special person, and that too could be subject of a will. And there are others who may have businesses, and you have to dress your mind as to what will happen if I die and my business, I have a very good thriving business. What will happen if I die and my employees, I have like 50 or 60 persons working for me? What will I do in a case like that? All of these things could be directed through your last will and testament. Also, sometimes some persons have property and they're thinking, or they live on a particular spot of land, or they have been given something from their parents, etc., or so they thought. But then if they don't have the title deeds, or they don't know how the property came into being, you have a situation where they may not necessarily have true ownership of that property. And the person giving it, it may be their parents, and the parents say, no, I give you this house here in Cane Garden, but then the house really isn't theirs, and they may be sharing it with a sibling as a joint owner, you know. So they may not know the title that they actually have to the property, whether they own it outright, whether they simply just have a life interest that is not assignable in a will. So there are many factors that could come up. So you have to sit with your attorney or figure out, what type of interest are you giving? Are you giving, or even if you own the property outright, you may still have to ask yourself, when I'm giving this property to someone, am I giving them it for life, or am I giving them it, only for in the interest of their lifetime, and then to their children? What am I going to actually do? Am I giving them a joint tenancy? Am I giving them full ownership, absolute ownership? So those are some of the things you think about when you are drafting your will, so that later on there's no ambiguity and your gifts could pass to the persons that you want to give them to. So it says important to list your assets, list all your assets. You may have money on the bank, you may have statutory instruments, you may have a yacht, you may have bicycles, you may have a number of things. It's very important to list them, and also to make sure that you're not giving the same thing to several persons and cause the will to be in disrepute. Also, your attorney would know that when they're drafting the will, certain things such as monies and so on have to be specified, because in some cases, when the term monies is used, it meant even personal, even real estate. So there are lots of things that would come up. You would definitely want to know if you have your age, as we said, you have to be 18 years and up. We would also need to know issues of trust or any conditional gifts you may want to pass over via the will. There's certain things that may happen when you have a will that may cause it to be revoked or null and void. For instance, if you have a subsequent marriage after you would have had the will, that would kind of revoke the previous will. So you're trying to minimize at every turn what it is you have, and to ensure that what you're given would actually pass the test of time. So sometimes you may have a vehicle today. It may be a Toyota, maybe a nice little Toyota, but then you own a fleet of cars later in life. But when you did the will, you had contemplation that, you would give the vehicle to your daughter. But now you have several vehicles, and you've described the Toyota, and so she can't get any because you haven't properly described what it is you're going to give at the time of drafting your will. So careful drafting is very, very, very important. And consideration for what your beneficiaries would receive. So we can also consider certain sections within a will. So we would have like the commencement clause that identifies who the testator is. We also have like a revocation clause, And that basically seeks to revoke all previous wills. And as I expressed earlier, if you don't do that, then you may have a situation where the other will is still being looked at, and the court then has to determine, what was the intent of the testator at the time. So there must be a strong revocation clause stating that, this is definitely the last will and testament, and you revoke all previous wills. So an express revocation clause is important to combat any ambiguity from a prior will. It's also important for you to appoint a minor. Where there's a minor, you would also appoint, the court may appoint the guardian that you would have chosen for the minor. If you choose the minor to be the executor, as I said, sometimes we don't contemplate that our children may not be grown or at the time of our death. So you may have a situation where you may die suddenly and you have a minor child, and in your will, you would have expressed that that minor child would be the executor of your will, thinking that, it probably wouldn't be open for a number of years, but it so happens that this tragedy occurred, and you now have the court will now give the guardian of that child sometimes to be the executor carrying out your last will and testament. There's also the issue of children that are born. You may have some prior child, another minor child outside of your marriage that you may not have catered to in your will. And you would have to make sure that the court will then look at that will and void it if you haven't mentioned anything about that child that exists probably from a previous relationship or marriage, and you're just thinking maybe about your immediate family. But the court will look and say, well, no, we have a minor child here, and that child needs some attention, and they can choose to do what they think is in the best interest of that child. And that could be dissolving your property and giving that child a lump sum, a financial interest in the property, to ensure that that child rightfully, is able to grow up and exist. So there's so many factors. That's why it's so important to lay all the facts on the table, and in spite of what you may fear, let your attorney know so that the proper and the right will could be drafted. And if you're doing it yourself, that you would contemplate all of these things. So you wouldn't necessarily want to give something or leave nothing to your spouse when the rules clearly allow for your spouse to inherit. So you would have to really have a good draft, and the court would have to understand why you're not leaving anything for your spouse. Maybe your spouse is probably a billionaire and may not really need any of the gifts you have. Whatever it is, you have to properly account for certain people within your life when you dispose of your property, especially minor children and your spouse. Also, there are sometimes some people like to put what they want to have done funeral wise in their will. They want to say, okay, please bury me at Coral Ridge and whatnot. But it's important for you to understand that a will may not necessarily be probated prior to your burial. So none of that information may be adhered to at that time. And so the more practical way would be to perhaps have a letter written, a separate letter addressed to a near relative, and they would open it and know what your funeral wishes are. You can also make arrangements for, let's say if you have a life insurance policy, you can assign some of the benefits towards your funeral expenses, or you can have a separate account that definitely or money put aside for your burial and so on. Because the chances are of your will being probated to hear all of your funeral wishes and what you would like to be done, it may not be done in that time frame. But all of these things are things that we have to give thought to at an early stage, so that your personal representative can carry them out. So always make room for the unexpected. You know, some of you may be young, but you may contemplate marriage later. You may have a lot of debts and liabilities and expenses to be paid. And once that is the case, those have to be paid off first before anyone takes any share in your property that you're leaving behind. In addition, you want to ensure that you have covered all the possible assets that you have so that nothing is left out. Because if anything is left out and you didn't give it over, it will go to something called the residual clause, which it will just be distributed to all those persons who may be intended to benefit from your will. So it wouldn't go to any specific person. So if you did have, say, like a life insurance policy and it wasn't assigned and you didn't specifically advise or give any direction to how that money should be spent or who it should go to, it will go into the residuary clause and it may be split equally or in whatever specific shares you may have. So yeah, so we have all those aspects of a will. And again, if you have any questions, you could drop them in and I will take any questions that I can. So in terms of effectiveness,
yes, Renée. Good night,
yes,
Renée.
please.
Yes, please. Yes. I have a couple of questions which relates to some of the things that you've said before. So I'm not sure if you would want to take one or two of these at this point in time.
Sure, you can go ahead.
Yes, there's a question one relative to minors. And that question is, if you appoint someone to be a guardian of your minors, do that person take control of the money until the children become of age? So you appoint somebody as guardian.
Yes, the person would be in charge because they're going to be in a position of trust. They will be like the trustee for that child. So yes, they would be responsible for everything, every aspect in relation to that child. You could also have a separate trust fund being administered for that child as well, if you so desired.
Okay.
But definitely, if you're going to appoint someone to be guardian over your child, your minor child, that is what the court will give effect to.
Okay. Thanks very much for that answer. Second question, Renée, is if there's an obligation on the part of the testator to tell the executor about his role before appointing him. So if you are,
it would be prudent. Yes, I understand. It would be prudent if you're gonna tell someone, if you're gonna have a personal representative, that you will let them know. So even when you're going to file your will, you would give the slip that would be given to you, and you can give it to your testator. You would need the original will at the end of the day. But if you have a copy and you want to let them know, but you are my personal representative, that is fine. That is very fine. Because you want that person to be able to find the will. Because if you don't lodge it at the registry, you could also have it at home, which is not overly advisable, but you can have it at home and the person would then retrieve it. So yes, it's perfectly fine to let the personal representative be aware that you have done a will.
Okay. So as an adjunct to that, if you are appointing somebody as an executor, the only qualification is that that person is trustworthy, or that person must have a knowledge of the law relative to the execution of the instructions of the testator.
Generally, the person only has to be trustworthy. So once you are comfortable, it could be a sister, a brother, it could be a friend, it could be someone that you trust. Once it's that position of trust that you believe that they will carry out all of your wishes, that's the person that you could appoint. It doesn't have to be a legal person. Generally, when we're going to do the probate, the attorney at law is the person that would go and make the representation. And then once they get the grant, the person that is selected as the personal executive or personal representative of the deceased will take over and administer the estate.
Okay, thanks very much. One last question, Renee, before you continue, is another question which has been placed in the chat. Can the person who, so you've appointed an executor at your death, can that person refuse to read the will? And if yes, if that person refuses, what can be done?
So yes, there are several situations that would occur like that, where the executor refuses to read the will or refuses to go forward for whatever reason. But you have the opportunity to appoint more than one executor. So one of them could go forward or all of them could go forward. But when you're preparing your documents, you would account for the reason why this particular one isn't going forward. And that will be prepared in affidavit evidence. And once the registrar is comfortable with what was put out to him or set out to him as the reason, it can go forward. The probate can still go forward.
Okay. Thanks so very much, Renee. One last one is just in the chat. If someone told you that they left something for you in a will, so you are aware that somebody has left or included you in their will, can that will be read without your knowledge?
When you do your probate, you are subjected, well, you would have to do a series of advertisements. And this is legislated. So you have to follow the rules and put out advertisements for the reading of the will, etc., etc. And when most people come to the knowledge that, a will is going to be read, and they follow and they find out what is within the will. That's the opportunity that you would have. Once the probate is granted and you're supposed to be entitled to a property, a cow, a house, the dog, the family pet, the court has to give effect. That is legal and binding. And if someone does otherwise, it can be challenged.
Okay, thanks so very much, Renee. Those are the
Sure,
questions that we'll see right now. I have some more in the chat, but we'll bring those.
Yes, no problem. Feel free
on.
to bring them up, and I would be happy to facilitate the responses.
Sure. Okay. Thank you.
So where we're at now is we've discussed the fact that we would want to know that our will is valid. It follows all the formalities. We have a good draft. It is free from ambiguities. We're passing over our gifts, and there will be, they can easily pass because we've paid attention to our minor children. We've paid attention to certain key aspects of our lives, and we didn't leave out anybody that we should possibly state that the reason why we're leaving them out. We've appointed for a guardian for our minor children. We've thought about all those other things. So once we have executed the will, once we're comfortable with what we have, and the testators then draft the will, sign in the presence of the testator, we would then go and we would file our will at the registry. So then we have the event, the sad event where we may pass away. And what will happen is that the executor would retrieve the will or an attorney at law and apply for probate. So usually we have this situation where you don't have a will at all. And that would be a grant of letters of administration. So essentially the deceased next of kin, or any person entitled by law to a general grant in respect of the deceased estate, may apply to the High Court for a grant of letters of administration. But in this case, we're talking about a grant of probate because we have wills. We would do the right thing and ensure that we make preparation. And so we would look for a grant of probate or a grant of letters testamentary. But we understand why we would want to have a grant of probate and we would want to appoint an executor, because we know that when we die, our property is there left, and we want our estate, our money, our property, and our possessions that we leave behind to be distributed according to our intent and our will, what we want to have happen. So where a person dies, leaving a will and names a person or persons to take charge of his estate following his death, the person or persons named in the will, the executors, are required by law to apply to the High Court for a grant of probate. So this is a document that they will get. And once this is done, you would be able to administer the estate. You would pay the debts and liabilities of the estate. If a property is supposed to go to Tom, you would then have an assent done, and that property would then be transferred to that person. You would basically share all the gifts that the deceased has left for the various parties that they mentioned in the will, once you have obtained that grant. So just giving you a little idea of what actually happens. You have like an application and it's filed with the probate unit of the Supreme Court Registry. Usually an attorney at law who is familiar with the law and the procedures governing the administration of the deceased estate. And after they advertise the application, the registrar examines the full application to ensure that the facts contained in the application comply with the substantive and procedural requirements laid down by the various statutes. And then you will have your grant. So you can skip over to where we would have the checklist of documents that we may be required. So you would have your application, you would have an affidavit in support, and you would have an affidavit of search, because very often we may not know how much our testator has. He may have several bank accounts. He may have property in the USA. He may have a whole lot of wealth that he may not have been saying, he or she may not have been telling us about all along. So that's why an attorney at law can go out and do a search, a general search, and come up with all the funds that or wealth or property that is owned by this testator who is now deceased, that some of it may not even be mentioned in the will, because he may have become very rich after drafting the will and so several years prior, or he might have become very poor as well. But the important thing is to have an affidavit of value, which will say exactly how much the estate is now worth, and list all the items that were found during the search. And this would then have, you will also have the affidavit of attestation, and these will form the bundle of documents you're producing to the registry. So it's a fairly exhaustive process, but it's necessary in order to get the grant, because then the registry has to know exactly what is being passed, how much is there, and you also have to pay all the deceased debts and liabilities. So you would have your various supporting documentation. You would have your copy of your death certificate. You would have your original will. You would also have a certificate of delay. This is where there's an expiration of 3 years of the death of the deceased. You have to account for all these reasons why there is such a delay in having the probate. So the registry would then look over your documents, and if they have any queries at all, they would then come back to you and ask, or your attorney, and ask, why is this missing? Why is the name not consistent with that on the death certificate? There's so many areas where you can have a bit of a hiccup, but generally, once you have that good draft and you have contemplated all the areas that you should be contemplating, you should have a successful time. Well, your personal representative would have a successful time obtaining the grant of probate. Now, you do see a caveat and queries below point 10 if you're following the screen. And again, we know that we would want our will to be valid and effective and compliant with the statutes that are provided. So we have something called a caveat. And it's basically a procedure to prevent the grant of issuing an estate. And sometimes it's done without notice. And this could come about where persons might allege that, the will was not necessarily the last will and testament of the deceased, or the person was not of sound mind when they had drafted the will or executed the will. You can have a whole host of caveats being filed with the registry to stop the will from being probated. But in all of the cases, if someone is asserting these things, they have to bring proof. They have to bring strong proof that this actually happened. And once they fail in doing so, you would still have the wishes of the deceased being carried out. So it's not unusual for you to have persons objecting to the reading of the will, persons saying that is not the will, it was not that. And could you imagine if you wrote the will by yourself? No, they may say, oh, that's not his or her handwriting. It is not valid. It is not a fit. They challenge the will in every way. So that's why it is important to have someone who can understand the law and that can draft the will in the right way so that you would avoid any challenges, or even if you do have a challenge, it will not stop the grant of probate. So I will stop there and you can feed any more questions that you would like, Minister Bellamy.
Yes, please. We have a couple more questions in the chat. I think you might have touched on this already, but the question is, do I have to go through an attorney in order for a will to be legal?
No, you don't. You can draft the will yourself, but it would be advisable to have an attorney because the attorney is more familiar with the rules, the legal rules, and they can draft the will so they can avoid any ambiguity. They can direct your mind as to what you should be, as to things that you should consider when drafting the will. You don't want your will to fail because your signature was placed in the wrong place, or you didn't have your witnesses sign in front of each other. There are many things that could come up, or you might have written in some more information halfway through when you realize that you left out something sometime later. And all of these things present challenges before the court in terms of giving you the grant that you would desire. And if you don't get that grant, it's obvious that you have no control over how your property would be dispersed or so on. It would take according to what the law would require.
Okay, thanks very much. So here's another question, Renée. So I love my church very much, and I decided to put in my will that when I'm deceased, that all of my property is to be given to the church. You spoke about contentions and contentious issues. Can my family then contend with the instructions that I have left to give all of my assets, all of my money to the church?
Yes, they can. As I said, that people could challenge almost anything. But one of the reasons why, if you're married and you have a wife, as I said earlier, that your wife would have an opportunity, I think it is about 6 months, to challenge what you have written there because you're disinheriting her, and the law might allow her, say, half of your estate, Or if you had a minor child with a disability, the law might say she can take a quarter of your estate. But now you're giving everything to charity. But once you account for why you have done that, because you being a reasonable person, you might decide that your wife is quite well off and doesn't really need the house that you're going to give to the church, or doesn't need the property that you're going to think. Once you can account for the reason why, or she may be in agreement with you doing this, and the court can look and say, the registrar will look and say, well, enough evidence has been provided to prove why this is so. Yes, your gift will pass, but you have to ensure that when you draft it and the reason why you're doing this is documented within the will itself.
Okay. So it is necessary to document the reasons within the body of the will.
Yes, when you draft, you would state, you would have certain clauses within the will where you would account for why you're doing what you're doing. So it doesn't have to be in every instance. You don't have to say, give to my wife my car and my red car because she really loves the color of it. No, you don't have to do that. But if you're going to do something as drastic as exclude persons, definitely if you're going to exclude your children and their minor children, but you can't really get away with doing that because the court will always look at the interest of the child. So if you have a minor child within your marriage, outside of your marriage, you would be at lengths to have probate passed, a grant of probate, and your child is not taken care of. So issues like that will definitely stop a grant of probate going through. Or even if it did go through, the court can do as it deems fit in the circumstances. So certain things that you do, you definitely have to account for it in the draft that you would present and execute. And if you have legal guidance, it will definitely help you in the long run.
Okay, thank you. That's very informative. Here's another question. If you are not in a relationship with your spouse and the property is yours, does the spouse still have an entitlement to estate?
Okay, well, it's a bit tricky, but it is fact-based. So you may have a situation where persons they separate from their spouses, but there's no legal document to say that they're separated, and there's just an impromptu thing, so they live apart from their spouse. Now that would be a situation of fact, because there's sometimes when persons live apart and you would know they're in a happy marriage, but one person may live overseas and the other person is in another territory, and they meet up occasionally, and that's perfectly not formal and functional for them. And they have no challenges. They don't want to be divorced or any such thing. Now, you're in a situation where you live apart from your spouse. You haven't done anything legally to dissolve the union. You haven't divorced your spouse. It can lead into to some difficulty. And yes, in some cases, the spouse can still have part of your estate. So therefore, it is important for you to make all these separations quite legal and do the relevant things to signify that there is that dissolution of your marriage. Because there is a case, even in Barbados, and we recognize common law unions where people live together, but they're not married. And there was one very prominent case whereby the man was married, he was still married, or he at least, according to the law, he should have been married for 5, he should have been separated from his spouse or divorced legally at least 5 years preceding his death. And so his common law partner, even though they were married, she missed the date by like say a couple of days or so. It wasn't very long, it wasn't even a year. And she was unable to take any of his estate because of the fact that it was not following the letter of the law, and it wasn't a single man and a single woman. So yes, you can have a situation where you're separated, you have not done the legal thing to follow through with a divorce, and for some reason you die and you have not had the prescribed time apart, or there's no record saying that you were actually apart, and your wife could, yes, come and take your property. Now, conversely, some persons may be living together and they're separated and they cohabit, or not necessarily cohabit, but they live in the same space, but they're definitely separated. There are a lot of issues that it is best to have an attorney to guide you as to how you would navigate a situation like that, and to contemplate these things in the earliest stages so that you wouldn't have any trouble when you go for a grant of probate.
Thank you, Renée. That's very informative. Another question. So a person has 4 children and the will is made. The testator dies. But before the will is probated, one of the children who has a family also dies. Is that the person who has died, one of the children, is that person excluded from the estate, or the part of the estate then goes to that person's family, the family of the person, the daughter, the son who has died?
Okay. Again, that will come down to the drafting that is done in the will. If it is the testator's will that his grandchild or some other person will benefit under the will, they would have to draft it and word it in such a way that even if his present child passes away before the will is read, that the issue or the child from that child is catered to. And again, it would depend on how you draft it, because you can have a draft where you say to my children or to my son for life, but then to his children in full, in fee simple. And the children actually take the full benefit of the property, whereas, sorry, the grandchildren would take the full benefit of the property, whereas your immediate children only have a life interest in the property. So there are many ways in which you can, based on what you would desire, draft the will to suit those needs. And there's nothing stopping you from doing anything different, except if you have especially minor children or a peculiar situation, which the court will have to look at and determine.
Okay, thanks. Another question in the chat. What is the approximate time for a will to be probated? So the person dies. Does the law state that that will has to be probated in a particular specified time?
There isn't necessarily a specified time, but as I said earlier, if there is a delay of, say, 3 years, then you have to go into explaining why there was that delay in doing the probate, but not necessarily that there's a specified time. Generally, when you have a will or you're aware of a will, you would want to do it immediately after the person would have passed to get the relevant grants done so that you can give effect to the person's wishes. Because if you wait too long and the person has, for instance, a business and it's unless you get the will probated, they can't carry on that business. It would be futile to wait 3 years to then decide what you're going to do, because then the business may collapse or so on. So you have to give effect. You will try to give effect as soon as possible. If you have minor children and you have appointed a guardian, it will be prudent to let the will be read so that the guardian could take full legal effect and authority over the minor child. You can't wait forevermore to be appointed. And there are cases where if the person that is entitled to appoint doesn't appoint, someone else can take it up and go to the court and show why they are coming to the court for a grant of probate. It may turn out to be a different type of grant, a grant of letters of administration with a will attached. And they attach the will to show, well, this is what the testator really wanted to have happen. But this person is holding up the process and we can't wait any longer. So, and my advice would be to do it, the quicker you do it, the better for you. So you can give effect to the testator's last will and testament.
Okay, those are the questions that so far appear in the chat. So not sure if you want to proceed.
Okay, well, I would have ended my presentation there. I don't know if there's
Right.
anything you would want me to go over or
There's
if there's
another
anything.
question. Okay,
Yes.
there's another question. So there are times, Renée, when you actually see appearing in the newspaper a request relative to the property of an individual. So it is published in the paper, in the newspaper. Perhaps sometimes if anybody has any claim or anything relative to the estate of the deceased, is it mandatory for this to be done?
Yes, it's all specified in the non-contentious probate rules. And there's the period of advertisement that would have to take place. And that advertisement would actually form the bundle of documents that you submit to the registry so that you would show whether it's 2 successive Sundays or within 4 weeks' time or 2 months. I can't quite recall the exact time, but it's specified within the non-contentious probate rules that the property must be advertised or the estate must be advertised. It must be that advertisement in the official gazette as well as other places.
Okay.
So yes, it is mandatory.
Okay. And on a point of clarification, to bring clarity, I think you probably would have touched on it a bit earlier, but just for the sake of clarity, there are times when individuals pass away and there is uncertainty as to whether that person has written a will. So is it advisable if you have written a will to let your family know that you have done so?
Yes, it definitely is. And more importantly, when, at least in these times, when you have a will done, you would go and lodge it with the probate registry. So it's there and they have it, and you go and retrieve it when the person is dead. Because obviously there's a lot of uncertainty when leaving it with random persons, and suppose a fire, took place and it destroyed the will, or are there issues where a will is damaged and it can't be probated because of the state in which it is in. So the safest bet is for you to lodge the will at the probate registry and retrieve it upon the person. The personal representative would be made aware, and they would then retrieve that will when the testator dies. So that would be the prudent thing to do. You can't probate what you can't find. So
that's
yes.
very true. But I know that sometimes there's this uncertainty whether a will has been left, and you go dig in there and make inquiries here and there to determine whether the person actually left the will. Yeah?
Yes, that happens.
Yeah.
I have seen that. I have seen that happen time and time again. When persons come and say, I know there was a will, or they come with something else and they say, this is what the person left for me. But you can't give credence to it. The court wouldn't look at that. What you would have to have instead is a grant of letters of administration. So you're not going to have, if you can't find the will, we don't know where the will is at. We can't wait indefinitely, because then the executors might pass away. The witnesses might not be there to attest that, yes, they did sign on the will. The attorney that might prepare the will might go himself too, So there are a lot of evidentiary issues that may come up. So it is better to definitely file the will with the probate registry once it has been executed.
Thank you very much, Renée. One final question before we invite you to give your closing comments, and it relates to, maybe this is a personal perspective from your point of view, but would you say it is more expensive for a person not to leave a will for the family, that is, um, rather than leaving one? So the person that is intestate. So obviously you have to do letters of administration where you involve an attorney or whatever. Is that process, in your opinion, more expensive rather than if the person left a will? And maybe this is a personal perspective.
Now, if I'm understanding you correctly, whether you go through an attorney or you don't go through an attorney, if you're going to have a will, you're going to still face the same level of exercise. Like a person could go and request probate of the will, but more often than not, 95% of the time, it's the attorney that would do that. But you will still have the expense of doing the advertisements and all the other attenuating circumstances in terms of giving effect to the testator's will. At the end of the day, it would be, for me, what you personally would require. So a will is more than just leaving presents for persons when you pass. You're making arrangements for your young children, if you have such, appointing a guardian for them. You may want to give a special gift to, say, charity, to a church, or somewhere that you prefer, somewhere that probably looks after children. You want to give effect to what you have laid on your heart to give effect to. So it's deeper than just thinking about the expense after the fact. And it's unlikely, it's not really even, I'm not even able to predict what that expense should be if it's any more than not having a will and not directing, especially if you're a person that would have amassed a lot of wealth. Now, if you have not had much to leave back in your lifetime, and you don't have any children, you don't have any such things that would make you want to think twice, you feel free not to make a will, and it will just, the property or whatever will just devise in accordance with law. But if it is that you have minor children, or if you have an established business that may benefit many persons or hundreds of persons, or it could be simple, it could be a very homemade or indigenous something that you do, and you want it to be carried on, and you know someone that you would definitely want to carry it on for you. Those things are important to put in a will. And so it's a matter of your choice, how you feel personally about your wealth, and if you care enough to think about who you would want to have control of your personal possessions when you pass on.
Okay, very informative. Thank you very much for that clarification. We would now want you, Renée, to give your closing, if you have any closing comments before we officially bring this session to a close.
Yeah, thank you very much once again for having me. It's a pleasure coming to share with you and those who are listening. Thank you very much for listening to the presentation. I hope at the very least it inspires you to, put your affairs in order, even if you may not have a will drafted, at least have some understanding about what would happen, in the event of your passing. Put some thought to it, because very often we don't do that or until it's very late. Or sometimes we may have a situation where we do not understand the law and do not understand how we may even challenge a will or something that may not be right, So all those matters we can, I hope that it would have inspired you in some way or helped at least one person. And so thank you very much again for having me. It was a pleasure sharing, and hopefully I'll be able to come back some other time soon to go further into the areas you may want.
I'm sure that's a very great probability. We certainly want to thank you, Renée, for enlightening us on several aspects of wills and the completion of wills. Certainly our knowledge has been expanded exponentially as a result of this presentation this evening. I certainly hope that those of us who have been in attendance at this session this evening have been encouraged to give some thought, if we've not done so as yet, to preparing our wills, putting them in place. Who knows, it might go a long way towards keeping our families healthy after we are gone. Thank you very much again, Renée, for sharing your knowledge with us. And I want to thank you, audience, for your attendance and for your participation. So please join us next week, next Wednesday, as we look at healthy families, the nutritional and physical impact with presenter Miss Donna Barker. Thanks again for joining us. Good night and God bless.